Hello there and welcome to The Law with me, Mama Vio Swabwaje, sitting in for your regular host, Samson Ladi Ayenini. Now, this week, issues of Article 104 of the Constitution and aspects of Parliament's own standing orders have become a subject of controversy, with interpretations largely determined by which side of the political divide you stand. The main bone of contention has revolved around the question of quorum. Quorum for Parliament to take decisions such as approve or reject a budget. But there have also, in the last few days, been some debate on whether or not a or the Speaker has an original or a casting vote while presiding. As I indicated, partisan politics had largely influenced the legal interpretations and definitions around these legal concepts. That is why we have the law, where independent legal minds will help us navigate the complex web of legal jargons and constitutional context that has defined the major issues during the week. Well, my name is Mama Vio Swabwaje. I welcome you all to The Law. Let's introduce you to our guests who are joining us via Zoom. Professor Kofi Abochi is the Dean of the UPSA Law Faculty. Also joining us is Julius Opoku-Agyei with Opoku-Agyei & Co. Law Firm. And they are both joining via Zoom. First of all, I want to say hello and good afternoon to you, Professor Abochi. Hello, Prof, if you can unmute so we can hear you.
Yes, I just have. Good afternoon, Mama B. How are you?
Very well, thank you, sir. Thanks for joining. We will have Mr. Julius Opoku-Agyei. When he joins us, I'll bring him into the conversation. But Prof, let me start with you. We've heard a lot this week about original vote and casting vote. Can you explain the two?
Well, an original vote is a vote that inheres in a person as a result of his membership of a body. In this case, Parliament. The original vote of members of Parliament is the vote that inheres in them by reason of being representatives of particular constituencies. So they have a vote in the decision-making processes of Parliament. The casting vote, on the other hand, is the vote that is exercised whenever there's a tie. So it may not be an original vote. In other words, in some cases you have a person, a chairman, usually it's vested in chairman and presiding officers. In this case, the Speaker. The Speaker doesn't have an original vote. And the reason the Speaker doesn't have an original vote is because he doesn't represent any constituency. In addition, the Speaker presides. And by reason of the need to ensure bipartisanship and neutrality, the Speaker is not vested with any original votes. So the original vote is the vote of membership. The casting vote, on the other hand, is the vote that is vested in a person to often split decisions. So when you have a decision which is often a tie, the casting vote is often vested in the presiding officer, which is used to separate the sides, so to speak. So the Constitution did not really make a lot of fuss about the Speaker's original votes because it's a matter of fact. It goes without saying that the Speaker, by reason of not being a member of Parliament, doesn't have any vote. So that one is not an issue at all. But the Constitution was explicit in stating the fact that the Speaker doesn't have or enjoy a casting vote. And the reason the Constitution was at pains to say this is because in normal administrative practices, in the absence of any contrary statements, the expectation is that the chairman often reserves the right to cast a vote whenever the vote is a tie between two sides. And so the Constitution was clear that the Speaker doesn't have a casting vote. So the Speaker, in a sense, doesn't have a vote, period. Neither original nor casting.
Okay. I guess the controversy has been the Deputy Speaker. We'll come to that. But let me take you to Parliament, just briefly a recap of some of the events that happened.
Honourable members, the number presented to me by the clerks at table is 137 of you plus me, MP for Bekwai, 138. Honourable members, for the avoidance of doubt, let me read out the constitutional requirements so that there's no confusion as to who can vote what numbers are required to take a decision. Article 104(1). Except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting. The vote of the majority of members present and voting, with at least half of all the members of Parliament present. What it means is that before you take a decision, there must be at least a majority of all members present. With me, we have 138 members. That's a majority. It doesn't mean that all the 138 must vote yes or no. A majority of this 138, their decision will carry the day. So, I'll go ahead and put the question on the motion proposed before us. All in favor of the motion, say aye. All against, say no. The ayes have it. The motion is carried.
All right, let's get some understanding of what has happened in Parliament. We're talking about whether or not the Deputy Speaker of Parliament can join members of Parliament in forming a quorum. But I also want to introduce to you our second guest who's just joined the conversation, Mr. Julius Opoku-Adjei. Let me say good afternoon to you, sir. Thank you for joining.
Good afternoon, and thank you for having me.
Great. All right, so let's continue from where we left off, Prof, and perhaps I will come to you on this one, Mr. Julius Opoku-Adjei. Where do the members get the powers, the voting powers from? So the casting votes, for instance, who gives the casting votes?
The members get their power to vote by reason of their being members of Parliament representing constituencies. So they have original votes as members of Parliament. In Ghana's Parliament, there is no casting vote. The Constitution is clear that the Speaker does not have an original or a casting vote. The Constitution goes on to talk about a member of Parliament who is presiding, and states that a member of Parliament who is presiding over the sitting of Parliament, that will be one of the deputy speakers, will not have even his original vote. It is silent on the casting vote when a deputy speaker is sitting, presiding over a meeting. I presume, and we wait for a court interpretation, Supreme Court interpretation, that because the speaker does not have a casting vote, a deputy speaker presiding over a meeting doesn't have a casting vote either. So none of them would have a casting vote. But the Constitution makes it explicit about the original vote because the MP as MP has an original vote, which the Constitution says he cannot even exercise, when he is presiding over the House to take a decision.
So, Professor Abochi, the MP has an original vote, but if the MP is Speaker, sitting in the Speaker's chair, presiding over issues of the House, has he got a vote? What kind of vote has he got?
Let me start by saying that the events of the recent week, or is it weeks, have exposed a deep flaw in the Constitution. And I dare say this because it seems we have once again copied without looking at the nuances of our circumstances. The reason, now, so let me just answer the question at this stage, whether when one presides, whether he has a vote or otherwise. The matter has not been determined in court. But if you look at it from a purely extrapolative perspective, if you analyze the Constitution from the way it is structured, the expectation is that when a person assumes the office or the seat of Speaker, the person ordinarily will suffer all the liabilities or disabilities of speakers and will have all the rights of speakers. Now, in regular administrative law, an acting occupant of an office has all the powers of the substantive. That is the principle of law. And that person has all the liabilities of the substantive. That's the principle of law. Therefore, if we should follow the pure principles of constitutional law and administrative law, a speaker, an acting speaker of parliament, i.e. a deputy speaker who assumes the office of a speaker, has for the period of being a speaker, he suffers all the liabilities and disabilities of speakers, and he has all the rights and powers of the office of speakers. You can't have all the powers vested in you and not suffer the disabilities. In constitutional law and in law in general, you cannot create an imbalance. So a balance is the principle of law, and that means you have all the powers the same way you suffer all the disabilities. If you expand this, therefore, what it means is that when a deputy speaker assumes the office of a speaker, the deputy speaker suffers the liabilities of a speaker. And one of those liabilities of a speaker is that the speaker doesn't have a vote. He neither has a casting vote nor an original vote. That means that a member, or in this case, a deputy speaker who becomes a speaker, has for that period no vote. But in constitutional terms, and that's why I indicated to you that it creates a constitutional problem from what we see now. In constitutional terms, what that means is that we would have undermined his representative capacity. If you are a member of parliament, by reason of which you become a deputy speaker, for the period that you are acting speaker, if we should apply the principle of law that I just mentioned, which is still the principle of law, if we should apply it, what it means is that for that period, your people are not represented. You cannot vote, neither can you participate in the debates. You have to preside. And if you preside, because of the bipartisan character of your position, you have to essentially be quiet, and you have to show neutrality, and you can't vote, you can't take a decision. All these create problems, and if you extend it or expand it further, what that means is that in terms of forming the quorum of parliament, you cannot be counted for purposes of forming the quorum. So that creates a constitutional difficulty, and that constitutional difficulty therefore undermines the Constitution's own representative principle that a member of parliament shall represent his people, and nothing can undermine that for the period of his representation. So we have these difficulties, and it seems to me that I don't think these complications were thought through, with all respect, when it came to the framing of the Constitution concerning this particular part. I do not think that the complexities of Parliament was considered. Unfortunately, the Supreme Court has over the years described Parliament as being a master of its own rules, which is another problem. And the reason that is a problem is because for an institution that is fundamentally built on conflict, fragmentation, and division, it is very difficult to understand why we make it a master of its own principles, because that institution cannot even master itself. And the reason it can't master itself is because it is a conflictual institution. By nature, it is designed to debate, to discuss, to disagree, and to divide. And so if you make that body a master of its own self, a master of its own principles, or a master of its rules, you clearly have the kind of problem that we have. And it does seem that we may have to probably suspend that rule of Parliament being a master of its own rules and probably get a judicial intervention, because clearly the issues are more complicated at this stage. And if you ask me, I will go as far as to suggest that it may perhaps require some reflection on constitutional amendment as far as this particular part of the Constitution is concerned.
Mr. Pokoje, I don't know if your views are different from what has just been expressed by Professor Bochi, but if your views are the same, I want to ask about the interpretation given by the Deputy Speaker when he was sitting as Speaker of Parliament.
I agree in a large part with what Professor Abuchi has said, but I have slightly different interpretation or views on some of the matters. For instance, when you look at the wording of the Constitution, it says in the absence of the Speaker, let me go to the exact wording so that I do not misquote the Constitution, if I may be given an answer. But what it says is essentially that in the absence of the Speaker,
and this is exactly which article?
101 says the Speaker shall preside in Parliament at all sittings, and in his absence, a Deputy Speaker shall preside. The Speaker shall preside in Parliament in all sittings, and in his absence, a Deputy Speaker shall preside. Now, does a Deputy Speaker presiding over a sitting of Parliament make that Deputy Speaker acting Speaker? I have some doubts about that. Does he have all the powers that a Speaker has, or he has the powers of the Speaker in relation to that sitting only? I hesitate to interpret presiding over a sitting to equate as becoming a deputy speaker, an acting speaker, even for the purposes of that sitting only. So for that, my interpretation is slightly different, that a deputy speaker presiding over a sitting of parliament is not necessarily an acting speaker. Now, to answer your question, if I may,
please do.
The deputy speaker, who is a member of parliament for Bekwai, who was presiding over that meeting, first of all, signs the register of parliament as being present as member of parliament for Bekwai. In my opinion, he can be counted where the quorum is being looked at, because he is in parliament as a member of parliament for Bekwai. But he cannot vote, even though he can be counted to form the quorum, which was 138 for the purposes of taking a decision. When it comes to voting, the Constitution expressly takes away his right or power to vote, so he could not have voted, and I'm not sure whether the counting of the votes suggests that he voted. But in any case, it is, if you take his vote out, what will be left to be 137 votes? And it is a majority of those 137 people, not the majority of the totality of the members of parliament, but the majority of those present that day, who, by my count, by my interpretation, is 138, because the deputy speaker can't be counted, whose vote will be considered. And half of the 137, I think, is 69. So to get a majority, it must be 70. So all that was needed was for 70 of those present, of the 138 present, and the 137 qualified to vote, who should vote to pass the budget.
It's interesting, the interpretation that you also put on this, and I want to run it by Professor Abochi, but I also want to ask you, in view of what you've just said, is it the understanding that when the deputy speaker, who was already aware that the speaker was out of the country, when he entered parliament the day that he was going to preside, he entered first as MP for Bekwai before speaker?
That would be difficult for me to answer because of the process. I'm not sure of the exact procedure. But if you listen to him, he announced himself as the one person adding up to 138 because he's counting himself as an MP. And I believe he signed the register as member of parliament for Bekwai and not necessarily as a deputy speaker only or presiding member only. And what the distinction I'm trying to bring about is that a deputy speaker presiding over a sitting of parliament is not, in my interpretation, an acting speaker. He is a person presiding over that meeting or that sitting of parliament.
Okay, Professor Abochi, I just want your thoughts on this. Does the deputy speaker have powers of the speaker for a particular sitting only?
Well, correct, but that's the whole point. I mean, even the substantive speaker has powers for sittings and for sessions and for particular activities. So we are dealing with particular sitting for the period that he's acting as speaker. And we should not really extend this in terms of nomenclature because, what is the reality is the reality. The deputy speaker is supposed to act in the absence of the substantive speaker. So it's an acting speaker. You can call it whatever name you want, but that's the role. He plays the role of being an acting personality in the absence of the speaker. I reiterate again that in law, in constitutional and administrative law, a person acting in a position has all the powers of the substantive position and at the same time has all the disabilities or liabilities of that position. And so in this regard, we don't have to extend it. I mean, there's no point arguing something which appears rather obvious in this respect. My point is, if that is accepted, then what it means is that the acting speaker or the deputy speaker cannot have a vote, cannot be part of the quorum. But if you do that, what it means is that you would have created a suspensory position for his membership. What it means is that then by reason of suffering the disability of the speaker, for the period he's a speaker, his membership goes into a suspensory position. But that interpretation also then creates a constitutional anomaly And the anomaly it creates is because you undermine the membership of the member. And so for a period, his constituency are not represented. Again, from the standpoint of the Constitution, that would be an anomaly. And it'd be an anomaly because you would have undermined the representative capacity of the member. So it is something that calls for reflection for me in terms of moving forward, because I do think that either interpretation that is proffered creates a constitutional problem. And it's the same difficulties or complications that applies to the minority side when the first decision was taken. We haven't looked at that. But these complications are not just for one side. Because even the question of voting, presence and voting, which you mentioned earlier, if you look at Article 104, it says, for purposes of the decision making, the number must be majority of persons who are present and voting. For purposes of a quorum, the membership has to be more than half of all members of parliament. Now, it's important. I haven't had a lot of, if you like, clinical focus on this particular aspect when it comes to the discussion. A lot of the issues have been jammed up. If you look at Article 104, it is split into two parts. One part deals with decision making, and the other part deals with quorum. The quorum part says that you have to have at least majority of members of parliament, or rather, sorry, at least half of all members of parliament present. For purposes of the quorum, you have to have at least half of all members of parliament present. Now remember, it does not add voting, it says only present. And then when it comes to decision making, you have to have a majority of all members present and voting. So when it comes to decision making, even if there are 4 people, we just have to count 4. We just have to count a majority of that. In this case, 3. That's majority. But when it comes to the issue of quorum, you have to have at least half of all members of parliament present. The question is, how do we discuss or define presence? Does parliament have a logbook? Does parliament have a register? Does parliament have a sergeant at arms who documents attendance? If we do have this, how do we log in? If you enter parliament and you log your name in, that would be deemed as constitutive of your presence in parliament. For purposes of that particular session, you are present. What therefore constitutes absence? In my estimation, a walkout will not be absence, because you would have been marked present for that sitting. And so even if you walk out, you would have still been deemed present.
Well, apologies there. We seem to be having some breaks in the network, Professor Abochi's network, but he's been making some very important analysis. Professor Abochi, we have you back. We lost you briefly. Hello, Prof. Kindly unmute again. Okay, unfortunately, I think we have to work on that network and then bring Professor Abochi back so that he can finish, the analysis that he was trying to make there on Article 104. He explains there are 2 parts, in one, and he's been explaining that. But Mr. Julius Opoku-Adjei is also still with us. Do we have Professor Abochi back so that he can finish that statement that he was making? Okay, unfortunately, we don't have him back. But Mr. Julius Opoku-Adjei is with us. I don't know if you have anything to say based on the analysis so far being made by Professor Abochi.
I'll say that it's true. We have a number for the quorum. I agree with him on that, which is not the same as the number needed to take a decision. Because for there to be a quorum for a motion to be put, for a vote to be called, you need at least 138 members of parliament, because you have 275 members of parliament. And then when that threshold is met, then as many of them as would vote, majority must vote in favor for that question to be put, so that assuming out of the 138 persons present, as he was explaining, only 10 votes, then it will take a majority, the majority will be more than 5. That is 6 upwards for the vote to pass, so that you don't even need all the 138 who are present to vote, they should be present when the question is put, when the decision is being made, but they need not vote. Now, when it comes to the quorum again for decision making, how do you meet the 138? Again, I'm not in total agreement with Professor Abuchi. When the question is, the issue is what are the numbers in Parliament at the time the question is put? I don't think it is who signed the attendance register and then left the chamber of Parliament or the floor of Parliament to go and sit in a parliamentary office or go and sit somewhere. Who was present in the chamber when the question was put? That is what should determine the number of people who were present when the question was put. So if less than 100 and let's say in the morning 300 members signed, 250 people signed the register as being present, members of Parliament. But at the time the question is put, the number has fallen below 138. In my opinion, in my interpretation of the Constitution, that decision cannot stand, because at the time that the question was put for the vote to be taken, the members did not meet the criteria, which is at least half of the members of Parliament being present.
All right. We have Professor Abuchi back. I would allow you to finish the analysis that you were making there.
Well, so I was trying to deconstruct the concept of presence, that we need to understand what even presence means, because the key word Parliament uses is presence. And I'm asking if we have a way of logging people into Parliament, and therefore people say, sign a register when they enter. That means that once you sign the register, you would have been present in Parliament. What it means is that if at any point in time you get off your seat and you leave the chamber, and let's say you are still within the precincts of Parliament, or you have even left the precincts of Parliament, the fact that you would have logged on by way, in terms of your presence in Parliament, would imply that you were actually present. And the similar thing will apply if someone is in the chamber and the person decides to rise and go to the bathroom or use the washroom. That person would have still been marked present. So what constitutes presence? Does a person become absent merely because he comes in and leaves and probably comes back again? At what point did we say that his presence is over, or his presence was fleeting, or therefore his presence has been eroded by his absence, by his temporary absence from the chamber, for example? Yeah, hello?
Yes, we're listening to you. You've said it many times that Parliament is a master of its... Hello, Prof, we can hear you. I think we're still having some issues with his connection. We will work on that. But many times we've heard that Parliament is a master of its own rules. Mr. Julius Opoku-Eje, Parliament is not confused. Parliament doesn't have issues of interpretation, because we've seen the Deputy Speaker interpret matters. Is there anything that the Supreme Court is needed to do by way of interpretation, since Parliament itself is not confused?
Before I go on to that question, I made the point that in my interpretation of the rules, the number present for the decision to be made should be the number at the time that the question is put. And I take my inspiration for this from the standing orders of Parliament. Let me read standing order 108. 108.1 says, no question for decision in the House shall be proposed for determination unless they are present in the House not less than one half of all the members of the House. My emphasis is no question for decision in the House shall be proposed for determination unless they are present in the House not less than one half. So the question is, when is that question put for determination? Is it when they come and sign the register that they are in the House and then thereafter they leave the House, or when the Speaker actually puts the question? In my opinion, reading standing order number 108, it is when the question is asked, at the time the Speaker asks the question, who was within the chamber. Now, coming to Parliament being a master of its own rules, we take a lot of our parliamentary inspiration from the Westminster system, that the English Parliament. Now, the English Parliament, we say, is a sovereign parliament. They make a lot of things. The Ghana Parliament, I beg to say, is not the same as the English Parliament. we have a constitution which gives parliaments its powers. And the constitution spells out what parliament can do, what parliament cannot do. The parliament itself has gone on to make its standing orders. Yes, they made their own orders, they made their own rules. But everything that parliament does is subject to the constitution. And the constitution is interpreted by the Supreme Court. So whilst the court may be reluctant to intervene in what happens in parliament unless it is absolutely necessary, whatever parliament does is subject to interpretation by the Supreme Court. Now, is there or are there issues for the Supreme Court to determine in what has happened over the last few days? In my opinion, yes. For instance, can a deputy speaker sitting in the chair of the speaker presiding over a sitting count himself as adding up to the number to make a quorum? In my opinion, yes. There are disagreements. Professor Abochi disagrees with me right here on this program. So we need a definitive pronouncement on that from the Supreme Court. At least for that one, we need a definitive pronouncement. Can a deputy speaker or any other member, for that matter, sitting count himself as a member of parliament for the purposes of making up the quorum? We need an interpretation on that one.
Okay. Do we have Prof back with us? Because I want to put this question to him. Unfortunately, he's not back with us. We will continue to work on this. So, Mr. Pokweje, you insist that, yes, indeed, we need some interpretation on whether or not the deputy speaker can count himself to form a quorum. Even though we saw the member of parliament for Bekwai, first deputy speaker, interpret that to mean he could, and indeed that's exactly what he did. So there isn't, so for you there's still a gray area.
No, it's not a gray area for me. I agree with his interpretation. I agree with the interpretation of the member for Bekwai sitting as presiding over the meeting. But I also acknowledge that there are other lawyers and, of course, non-lawyers who disagree with that provision, that interpretation. That is why I think that it would be good for the Supreme Court to take a decision and put the matter to rest. We don't know when we will be faced with such a situation again.
Let's go back to some of the people who are asking very interesting questions in terms of whether the speaker himself, Alban Bagbin, when he returns, if he can reverse some of the decisions that have been taken in the past few weeks or days.
The speaker presides over parliament, but he is not a parliamentarian. The decisions of parliament emanate from the elected members of parliament. The speaker will guide them. The speaker will decide whether or not you have followed the rules. The speaker will put the question and preside over the election or the voting. But the speaker cannot reverse what has been done. It is only members of parliament who can, of course, going by the procedures of parliament, reverse what has been done if they don't agree with it, depending on how the voting goes on the matter. So my simple answer would be no, the speaker as speaker cannot reverse what has been done. It is the members of parliament who can reverse it if they want to.
Okay. I'll come to the issue of when the speaker himself returns and he presides or he sits in the chair, can there be another motion to rescind decisions that have taken place so far? But before that, Professor Abochi joins us. He's been having some issues with the Zoom, so he joins us via phone. Prof, just to get your thoughts on the issue of can a deputy speaker count himself to form a quorum?
Well, I think that's the point I was explaining earlier in terms of the question of persons, but specifically related to the deputy speaker. If I tried laying the argument or breaking it down for people to follow, but for purposes of the deputy speaker, if we accept that his membership can never at any point in time go into suspension, then of course the deputy speaker remains a member even for the period he is acting as speaker. If that argument is accepted in terms of the logical structure, if that argument is accepted, then what it means is that the Deputy Speaker can count himself as a member, because he is a member for all time, at all times relevant. And if that conclusion is accepted, then it means when it comes to the counting of membership, the Deputy Speaker, whose membership remains active at all times, can count himself as a member. But again, that's why I said there are a few inconsistencies in terms of the rationale of the Constitution, because once you go in the direction of the Deputy Speaker also remaining a member at all material times, then his partisan character, indeed he's a party person, don't forget that, but then the expectation is that when he assumes the office of Speaker, he would have become bipartisan. He would have become neutral. He would have become a presiding officer. But once you accept the fact that he remains a member, then it means, even logically, he can participate in the debate. So he's not just a presiding officer, but he can participate on a party side, or he not necessarily political party, but in the sense of belonging to a particular side of the argument. So the Deputy Speaker can take sides. The Deputy Speaker who has become Speaker can, for all practical purposes, manifest the divisions that are in Parliament, even when he sits on the bipartisan neutral seat of Speaker. These create complications that undermine the essence of him assuming that role, and that's why I said it appears that the framers may not have reflected over some of these things, and I think it clearly has created the kind of incongruity that is not acceptable, so to speak.
Okay, so just before we lost you, I was asking the question of, you in particular, you've also said many times that, or reminded us because of previous decisions of the Supreme Court, that Parliament is a master of its own rules. And I said that the Deputy Speaker did interpret that there isn't any grey areas for Parliament. Why is an interpretation necessary?
The rule of Parliament being a master of its own rules is based on the concept of separation of powers, in which the court, through the Supreme Court, would not like, so to speak, to intrude into Parliament in terms of the internal processes. So the Supreme Court has described the rules of Parliament as a closed book. The things that happen in Parliament are in a black box. The courts don't want to know, and they just don't want to interfere. It's Parliament's business. My argument today has been that while that rule has served us for the better part of 3 or 4 decades, the problem with that rule now is that it is given to an institution which is fundamentally conflictual in character. The institution of Parliament is one that is fragmented, divided, conflictual, and is one that prides itself on division. If you have an institution that is a master of itself or master of its own rules, but that can't agree on key things in terms of the interpretation of its rules, then you have a problem. Of course, the assumption is that the Speaker will give a definitive and final decision or final interpretation as far as these are concerned. But clearly, as we have seen, we've seen a case of the Speaker's position being thrown into conflict. And the reason why it's been thrown into conflict is because you have a decision that has been taken by a substantive Speaker. And the substantive Speaker, for whatever reason, is not available at this stage. And then you had a Deputy Speaker, together with the majority, having to rescind that decision. And as you were asking, people, I'm sure, are contemplating what the action will be when you have a substantive Speaker in the seat and whether there will be another attempt at rescission. I think clearly the position of the Speaker itself at this stage, and it's not just the Speaker, but the Speaker has tried on many occasions to demonstrate bipartisanship. But in the past, you have speakers who have been openly accused of clearly showing favoritism to one side. And so the position of Speaker itself has over the years not been free necessarily from the accusations of partisanship and of bias. That creates further difficulties for this principle of Parliament being a master of its own rules. Because as you've seen, you've had very active actors in Parliament rejecting interpretations that have been placed on particular rules by the Speaker, whether it's the Speaker or, as it is now, the Deputy Speaker acting as Speaker. So that principle of Parliament being a master of its own rules, I think, is clearly coming under strain, and the question as to whether it will stand the test of time is one for debate by everyone.
Can I get a direct response to the issue of whether or not another motion for rescission can be moved when the substantive Speaker returns, and so we'll see all the decisions that have been taken, i.e. approval of the budgets, being rescinded? Yes.
Parliament is always given a vested with the power to undo its own action.
and Parliament does its own action by normally passing a motion of rescission. So Parliament can repass another motion of rescission. As to whether or not it will pass in terms of numbers is an issue for consideration. But as to whether the attempt can be made, i.e., a motion can be moved to attempt to rescind what Parliament has done, that clearly is allowed and that can be done.
So, Mr. Pokweje, where would this leave us then? Because we still have both sides strongly holding on to their views. Hello, Mr. Pokweje, do we still have you? Kindly unmute so we can hear you, sir.
Yes. I don't believe a motion to rescind the decision to pass the budget will succeed because of the numbers. This is just practical reason. It can be tabled. The speaker may admit it, put it to a vote, but unless the parties are very sharp about who is present and who is not present, it is not likely to succeed. That is my position. Another one can be done. So it is on the passing of the budget would stand unless a court decision announces it. If a court holds that the 138 threshold was not met because the deputy speaker should not have accounted himself whilst he was presiding, then that constitutional threshold of 100, at least half of the MPs being present before any question is put, would not have been met, so that it will not stand. But that will be up to the court, because I don't think Parliament itself, even though it has the power through a motion for rescission to set that decision aside, I don't think that the numbers as they stand now would allow for that to be done.
Let's go back to Mr. Gbagben's ruling. Do you think that there was proper quorum formed then when the budget was rejected?
No, I don't think there was proper quorum. There were 137 members in the House. The NPP had walked out at that stage. And by my counting of when the more than half of MPs should be present, it should be when the question is put. At the time, if I remember the sequence of events, the question that had been put was whether or not the finance minister should be allowed to address the House. That is what agitated, it was at that stage that the members of the majority became agitated and walked out. So when the question was put about the budget, then PP members of Parliament had walked out, leaving 137 members in Parliament, which is below the 138 members, which was the requirement for the question to be put in the first place. When the question was put, let me emphasize here, when the question was put about whether or not the finance minister should address the House, the question was put properly because there were 274 members present. But at the time the question was put about the budget, whether or not it should pass, the majority haven't worked out. There were only 137 members present, and that is below the constitutional threshold of 138 members present.
All right. Professor Bochi, an answer to this question. When Mr. Gbagben, ruled that the budget had been rejected, do you think there was a proper quorum formed then?
Well, as I indicated, once again, we go back to the issue of presence. What constitutes presence? If Parliament has a logging system of determining who is present, and that logging system is met, whether if a particular person walks out or a group walks out at that time, whether that walkout of itself will suffice to undermine the determination of the person or group having been present. These are things we haven't looked into or we haven't tested, and as I indicated, it can be more complicated than that. If, for example, a person is in the chamber and he decides to use the bathroom, and then the question is put at that time, whether in counting the people who are present in Parliament at that time, whether it will suffice for determination on whether the person is present or actually is absent. The question is, if there's a system for determining presence in Parliament and it is through a register, my own understanding ordinarily would be that once the person logs in for a particular session, the person would have been deemed present for that session. It will be counted present. If you do have, let's say, minutes of a meeting and people signed the register and subsequently left before even the meeting was over, they would have normally been deemed to be present. But again, the Constitution expects that you're not just present, but when it comes to the issue of decision taking, you are present and voting. But it's important to split the two. One requires presence and voting. The other requires presence. There are two different things. The one that requires presence, just presence, is the issue of the quorum. The one that requires presence plus voting is the one that has to do with the decision making, which is the voting aspect. And the two are normally jammed up together. So your presence is required for quorum reform, but the issue of voting requires not only your presence, but also your presence plus your participation in the voting process.
Okay, so I guess my question is related to present and voting. In that case, did we have the proper numbers, that rejected the budget?
Wait, which one are you referring to? The first one?
Yes, I'm referring to the first time when the budget was rejected.
But that's the point I'm trying to explain. That
I'm just trying to squeeze a direct answer from you. I get the breakdown that you've just made.
Yes,
I'm just saying that did we have members present enough and who also voted legitimately to reject the budgets?
Okay, because I'm not a court, usually I don't give these definitive answers. I give the principles, I break it down. Here's the thing again. If there's a system for logging in or registering members who are present, and if all the members who walked out had actually been logged in as present for that particular session, then what it means is that for purposes of presence and determining a quorum, they would have met that threshold. But that depends on, and I'm not utterly familiar, I have to be honest about this, I'm not utterly familiar about the login process as to how members come into the house, whether they sign documents, etc. But if there's a process, and they had met all that process, and assuming that something had happened that day, and parliamentary proceedings had been brought to an abrupt end very suddenly, and for purposes of the Hansard, we have to determine members who were present for that day. I think everybody...
And the Hansard has been, clear on that. 137 is said.
The Hansard said 137.
Yes, sir.
Then that's what it is. So then exactly. So which means the Hansard group, Parliament through the Hansard, has a process for logging in members and attendance and presence. And Parliament has determined that for purposes of presence for that day, there was 137. The issue is not subject to discussion or debate. Straightforward.
All right. We have a bit of time to take your phone calls. If you've got questions or comments, you can reach us on 0302 211 69 102 and as we wait for the phone calls to come in, just this bit of we saw the kind of disturbances, maybe not the same extent, on the 6th going into the 7th of January 2021. We didn't see any committee set up to look into the matters. We're here again with a similar matter. I wonder, what kind of intervention could be made to stop these scenes that we keep seeing from Parliament. And I'll begin with you, Mr. Julius Opokweje. Hello, Mr. Opokweje, but before you even come in, we have a caller. Abdul Fattah, thanks for joining us. Let's hear your thoughts.
Yeah, thank you very much, Madam Mamavi. We're very grateful this afternoon to listen to your program. Adam, and good afternoon to your panel over there, most especially Dr. Professor Muchi. And then I have a question for them. I hear some argument that if the Deputy Speaker is to relinquish his power on being a member of Parliament, not taking part in the decision making, then that he will be denying the people of his constituency. I forgot the constituency he's coming from.
Bekwai.
Bekwai, right. And I also want to ask, if that principle is to hold, what about the people of Lolobi and Akpafi and those people who have been denied to be an MP to be in Parliament, or that is made to also make a difference? So what I want to find out from the legal perspective about that.
Good question. Thank you very much. Do we have another caller on the line? Okay. All right. So this is not directly related to what we're discussing, but it's also a very legitimate question because they still don't have representation in Parliament. But let's... Hello, Moses? Hello, Moses. Good afternoon. You're on air.
Good afternoon.
Yes, Moses.
Hello, Moses.
Yes. Moses, kindly turn down the volume on that television set. We're getting some feedback. And if you can be real quick, because we don't have a lot of time.
Can you hear me?
Yes, I can. Moses, please go ahead.
Yes, I don't know, Mama V. I think these our politicians are actually toiling with our life in this country. At one point, they explained the law to favor whatever they are planning, but common sense does not apply again. So I ask Mama V, what are they teaching us with the young ones?
Okay. All right. Thank you very much, Moses, for that. We just have, some few minutes left, and I would appreciate it if the issue that I raised in terms of what kind of intervention, do we have a responsibility as a state to put in place some kind of measures, even though the legislature is an independent arm? But we keep seeing chaotic scenes in Parliament. What has recently happened is not the first time. So what can we do in that regard? Mr. Julius Opokoje, I wanted to start with you.
Yes, as a Parliament itself has put in place a 20-member committee to look into the events of last the Friday when the budget was rejected, and then on Tuesday when the budget was passed as well. So I want to believe that that 10-member committee, I think 10 from the majority side, 10 from the minority side, will do us all justice by properly delving into the matter, looking at what went wrong, looking at who to sanction if sanction is required, and maybe changing the rules and enforcing whatever rules that are there now to ensure that these kinds of scenes do not repeat themselves. But yes, outside Parliament too, we have laws which govern the nation. So if Parliament is reluctant or unable to deal with its own members for whatever reason, the rules of the nation apply to everybody. They are not suspended from within the precincts of Parliament. So if something has happened in Parliament and we deem it a breach of our criminal laws, the state can also enforce those laws. But I don't think it should come to the situation where the state would intervene externally into what has happened in Parliament, what is going on. I trust and believe that Parliament itself will have a remedy for us.
Professor Bochi, just finally on this, it's easy for our MPs to misbehave and be irresponsible and come back and apologize and set up a 20-member committee to look into the matters, isn't it? But have they really repented, or is this the solution, or it will happen again?
Well, I think the suggestion that Parliament should perhaps do some introspection and try and create that corporate united front that we all, clamor for. I think that suggestion is well made. Now, it's important, again, as I have said many occasions, and I repeat again, that Parliament is the strongest of all the constitutional bodies if you look at the powers that are allocated to Parliament. But in practice, Parliament has been the weakest since 1992. For the first time, we seem to have some hung Parliament of a kind, and the expectation is that we're going to have the members of Parliament work really as a team to confront the executive and then to hold the executive accountable and to make sure that things are done the way they have to be done. At the same time, government business has to move on. Nobody wants to see government running short of cash, and by reason of that, the economy, as it were, collapsing, and then we're suffering the consequences for it. So ultimately, it's important that the constructive engagement with the executive be had, but that can only be had if Parliament itself as a body can speak with one voice. And it's important that the partisanship be played out a bit so that government business is approached in a constructive perspective.
Great.
So I would also hope that the committee would probably approach things from that perspective so that the proper accountability, government is held to proper account, but at the same time, government is not grounded by reason of a certain lack of a certain gridlock due to partisanship, which unfortunately appears to be playing out.
Professor Aboche, it's important that I make this correction. So Friday's Hansard showed that there were 274 members present. And on that note, gentlemen, I thank you very much for your time on this very important conversation of quorum and voting in Parliament. It's been a lot of conversations throughout the week, and I hope that this conversation on the law has broken issues down and you understand the matters a whole lot better. My name is Mama Vio Swabwaje, sitting in today for your regular host, Samson Ladi Ayenini. Thanks for your company.